A very good afternoon, everyone. So, we are here with a discussion on the General Studies Paper 2, Polity and Governance part of our discussion. And the discussion is going to be quite helpful for all those who are either, no, who have either appeared for the current mains examination, or specifically it would be very helpful for those who are going to appear, in the upcoming years for the mains examination. Okay. So we are going to look at the topics, the questions that have been asked. We are going to trace which topics they have been asked from. And then we are also going to see to it as to what exactly are the basic demands of the question and how you would address them. Okay. So without any delay, let's begin with our discussion. Let's begin with the very first question that was asked. Yes, a very good afternoon to all of you. A very good afternoon. As I've already told you, the discussion of polity and governance part uh, of General Studies Paper 2. This would be, this is going to be, this is going to be very, very helpful in the, it is going to be very helpful for your upcoming mains examination, how to attend those questions, how to, structure your answers. We are going to take all of those discussions into consideration. Okay. So yes, let's begin with our discussion. Let's see the very first question. See the very first question. The first question says that discuss the corrupt practices for the purpose of representation of People's Act 1951. Analyze whether the increase of assets of legislators and or their associates disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practice. Consequently, what? A corrupt practice. So what are the things that we have to look into here? First of all, if we break this particular question and look at the requirements of this question, the very first thing is that this question, you have to first of all define in this question as to what exactly are corrupt practices in accordance to Representation of People's Act 1951. In accordance to what? Representation of People's Act 1951. So we have to see the provisions related to the 1951 Representation of People's Act, and along with those provisions we have to analyze. So this part is a factual part where we have to, if we know the law, if we know Representation of People's Act, if we know section 123 of the Representation of People's Act, section 123 of Representation of People's Act, because it is this particular section which deals with what are the corrupt practices. Okay. So if we know section 123 of the Representation of People's Act, we would be able to answer the very first factual requirement of this question. And once we have answered the factual requirement of this question, now we would have to look at the next part of our discussion, which would be what? The next part of our discussion would be, we have to analyze whether whether the increase of assets of the legislators that are there, whether it comprises of disproportionate. If the increase is disproportionate, can we say that this will constitute undue influence and consequently would it be a corrupt practice? Okay. So in order to address the very first part of the question, we have to look at what the law says. And the law, as I said, section 123 of the Representation of People's Act, what does it do? Section 123 of the Representation of People's Act, it defines and it categorizes what are the corrupt practices. So it says corrupt practices includes bribery, undue influence, appeal to religion, caste, community, race, or language, promotion of enmity or hatred, use of national symbols or religious places, exceeding election expenditure limits, false statements of facts, hiring of vehicles. Now, when we say, no, when you look at this, there are certain things which you have to understand here. First of all, if we talk about undue influence, just by calling it undue influence would not suffice. We have to define what undue influence here is. So undue influence here is what? When there is any specific step which either directly or for that matter indirectly interferes or intervenes in what? Free exercise of electoral rights of voters. If it intervenes free exercise of electoral rights of voters, that means if there are threats, if there are inducements, if there are spiritual or communal coercions, if that is basically the case, that would comprise of undue influence. Okay, so this is a very important term, because this undue influence, you can see undue influence is also a term which has been asked in the question. So now we know what exactly is the definition of undue influence. Okay, and we now know that it is basically if there are threats, inducements, or any form of spiritual or for that matter communal coercions that are going on, that would comprise of undue influence. Okay. Now, along with this, we have seen what are the other aspects of corrupt practices. Hiring vehicles for free conveyance of voters to polling stations, or for that matter exceeding expenditure limit. This expenditure limit is set by the Election Commission of India. So the Election Commission of India sets what can be the limit for elections of the MPs, what could be the limit of elections, expenditure limit of elections of MLAs, and all the candidates who are contesting elections, they have to keep their expenditure below those limits. Okay, so when this is what the corrupt practices is. Okay, now let's come to the second part of the question. The second part of the question gives a factual statement about disproportionate rise of assets, not only of the individual who is going to contest elections, but also of those individuals who are their relatives. If there is a disproportionate asset, disproportionate increase, now in that case, can we say that this comprises of or this constitutes undue influence? The answer to it is obviously no. Okay, so the kind of factually, if we look at the statement says that this will not comprise of directly, it cannot be considered as directly related to corrupt practices or undue influence. Okay, because we know that increase of wealth is not considered to be what? It would not be considered under the definition of section 123 of the Representation of People's Act. Okay, it cannot be considered that. However, if we look at other forms here, like if we look at this particular part, hiring of vehicles, if we talk about exceeding electoral expenditure, or if we talk about bribery, or if we talk about undue influence in the form of inducements. Now, this is where what you have to understand is that there is a possibility that if there is an individual there is a disproportionate rise of the individual's asset, in that case the individual could use that in order to unduly influence the voters, or for that matter may exceed electoral expenditures in a way. There are lot of expenditures which are taken up by the candidates which are not necessarily disclosed by them, because we know that in India, when it comes to election expenditures, there are practices which still continue despite the election commission's model code of conduct. There are practices like no cash for vote. This practice is something which is very much there in the Indian elections. Okay, so in this case we have to connect, while we are writing this particular answer, though we have to mention here that though it is not directly connected to it, but there is a possibility and there can be an indirect connection for this. Okay, so what would be the legal framework? We will talk about the bribery, undue influence. We will also talk about electoral expenditures. Okay, we will also be talking about electoral expenditures. Okay, we will mention this and we would analyze how we would analyze that. We would analyze that though it is not a corrupt practice, but it can be misused to influence voters. We will talk about that. And we also would mention that there is a opaqueness that is there in the financing of the election campaign. That is there is opaqueness, not everything is disclosed. So in that case, what are the specific steps that can be taken by the Election Commission of India to ensure that there is more transparency with respect to that? That is also something that could be mentioned here. Okay, but the very first part of your question, it should be about what, where you mention what is section 123, what are the provisions related to it, and then you come to the conclusion that though it is not directly related, and then you come to the analysis part which has been asked as to how, because of the components of what is written in section 123, there is a possibility of this misuse through what, as we have seen bribery, as we have seen undue influence, as we have seen electoral expenditures. Okay, through this what we can write, through this what we can present there, we can present that yes, though there is no direct connection between the two, but there is an indirect connection that is there. Okay, now how can you conclude this answer? So in conclusion of this particular answer, you can talk about electoral reforms. You can talk about electoral reforms in this particular discussion. You can talk about certain committees, specifically mentioning the Dinesh Goswami committee, also mentioning about the Administrative Reforms Commission and how they have recommended what? They have recommended, these committees have recommended state funding of in order to do what? In order to ensure that there is more transparency with which elections are conducted in India, there can be some recommendations which were given by Dinesh Goswami committee. It could be looked into and accordingly some arrangements could be made in order to ensure more transparent more transparent conduct of elections in India. Okay, so that is the how you can conclude this very answer. Okay, moving on. Look at the second question. The second question is a very easy question which has been asked from administrative tribunals. In fact, this time if you look at the whole paper that have been asked from polity and governance part, more or less the questions that were asked were predictable by nature, more or less. So if someone has even completed the basics well and you have thoroughly looked at the syllabus, you have completed the syllabus thoroughly, you will find that you very much are likely to be able to answer all the questions that have been asked here. Anyways, let's see. First of all, what is the question? The question talks about what? The question talks about administrative tribunals. The question talks about administrative tribunals, okay? And a comparison with the normal judicial courts in that of India. Along with it, it talks about recent tribunal reforms which was taken up in the year 2021. So we have to look at, we have to mention in the question what were the reforms that has been taken up, and through those reforms, what has been the impact? Has there been some positive changes? That is what we have to write here. Okay. So we can start the question by providing for providing for the constitutional provisions related to administrative tribunals. We can talk about the constitutional basis of it, that is it being introduced, and the articles related to it, article 323A, article 323B, which talks about other tribunals. Article 323A talks about administrative tribunals, and article 323B talks about other tribunals. So you can mention that constitutional provision. Along with it, you can also mention the need for, along with it, you can also mention why do we need tribunals. So you can mention about how tribunals do what? They specifically play a very important role to reduce the burden of the courts. Along with it, there are specialized expertise that it has. Like if you, case in point, if you look at certain examples, the NGT, National Green Tribunal, the Tax Tribunal, these are what? These are specialized bodies. Okay. So one of the most important, aspect of this discussion here is that when it comes to tribunals, with the growing complexity in the governance process, growing complexity. Now, we are not living in the 18th, 19th or the 20th century where governance used to be considerably simpler. Today, what you see is that the governance has become more complicated. And because of the governance becoming more complicated, the disputes have also grown in complexity. The disputes that are there, the disputes have also grown in complexity, which means that today, very likely, the normal judicial system that we see, that judicial system may not necessarily be able to, not necessarily be capable of doing what? Addressing these concerns. Because when we talk about judges, judges have good knowledge of the law, but judges do not have very good understanding of the complexity of these specific areas. So they may not be very knowledgeable related to environment or tax related matters, and so on. So because of that growth of complexity, there has to be what? There has to be a specialized expertise that is there. Okay. Now, along with that, there also the procedures are simple. If you look at the judicial processes that are there, the judicial processes are governed through complex laws. But for tribunals, that is not the case. Tribunals are just governed by the principle of natural justice. So there are no complicated procedures. There are no complicated procedures guiding tribunals, which makes the functioning of tribunals more flexible. Okay. Along with that, accessibility and speedy justice. As we know that today you would find that the tribunals that are there, these tribunals are, the tribunals have emerged because of the pending cases and the delays that the normal judicial process takes. So in order to address that also, we have emergence of tribunals. Okay. Now, what are the specific reforms that have been taken up in 2021? The reforms that have been taken in 2021 is that there have been certain tribunals which have been abolished. Then there are uniform service conditions which have been created. So now the members of tribunals that are there, all tribunals have uniform service conditions. Okay. Then most importantly, there has been a selection committee which has been established. A selection committee which has been established, a selection committee including what? Government nominees, reducing the excessive role of judiciary. So where judiciary used to play a very important role, there has been what? Reduction of the role of judiciary when it comes to the appointment to the tribunals. And then the tenure that is there, tenure has also been changed. It has been fixed to 4 years. Earlier it used to be 5 years. Okay, so these were the changes that have been brought. Some tribunals which were found not to be that effective, they have been removed. Some uniform service conditions have been created. There has been a selection committee and some reforms related to that. And finally, there has been a change in tenure as well. Okay. Now, what is the positive impact of it? The positive impact of it is obviously there has been streamlining of the system. Those tribunals which were not effective has been done away with. There has been uniform service conditions that have been created. So what has it done? It has streamlined the working of the tribunal, the administrative part of the tribunal. Second, there is judicial clarity, which is what? High court's jurisdiction has been restored in the area where tribunals have been abolished. Okay. As you know, if you have read Article 323, you know that the constitution initially, the provision that was there, it specifically prohibited the interference of the high courts related to the judgments that have been given by tribunal. But the Supreme Court in one of its judgments said that because the high courts have writ jurisdiction and therefore they also have the power of judicial review over the decisions of the tribunals. But the Supreme Court came up with an idea that the High Court should not take up all the hearings of all the decisions that have been given by the tribunal, and there should be some kind of rationality that should be followed. Okay, this was what the Supreme Court had to say. Now, because some tribunals now they have been abolished, so high courts which were prohibited and generally did not used to interfere with the working of the tribunals, now their jurisdiction has been restored over that area. And then comes cost efficiency. Cost efficiency, why? Because there were number of small tribunals. Now that small tribunals that is there, it has been done away with. Most of it has been done away with. Okay. However, what is the criticisms here? Judicial dependence or judicial independence, most importantly, because see, when we talk about the selection committee and the tenure that is there, now when the government tries to redefine how the selection to the tribunals are to be done, what we cannot forget is that these tribunals are quasi-judicial bodies. And because they are quasi-judicial bodies, to a certain extent, there should be separation of powers that should be extended here as well. So the independence of such bodies are a very important point. Even when we talk about effectiveness of these bodies, the effectiveness of these bodies would be dependent upon its independence. Okay, so that area is also something that has to be taken into consideration. Okay, then there has been reduced specialization. Why? As we have seen that in some cases, because of the tribunals that were there, smaller tribunals, they have been taken away. That means they have now been done away with, which means that the same part that we discussed, that today the governance has become very complex. That is something which has to be taken into consideration here, because if you are extending the jurisdiction of the high courts on those issues, very likely that the judges do not necessarily have the technical skills to address the concerns there. Okay, then comes access to justice. Now again, tribunals are there in order to make justice more flexible make justice more cost effective. But what has happened? Because of the removal of those tribunals, now the high courts, which are already burdened, there would be a further burden imposed on them. So that has become a problem. And there has also been what? A reduction of the tenure of tribunals. Now, what will that do? It would discourage talents. Remember, tribunals do not have tribunals do not just have no tribunals do not just have judicial members. There are also specialists and experts that are appointed to these tribunals. Now, when they have a smaller tenure, very likely they would not be encouraged to join such tenures. Okay, that would do what? That would make the working of the tribunal less effective. Okay, so these were the 2021 reforms that are there. Now comes the conclusion part. Now, what would you write in conclusions? In conclusion of this particular question, what you can do is you can you can further suggest you can further suggest what? You can further suggest reforms. You can further suggest some reforms related to what additionally needs to be done. Like when it comes to membership of the tribunals that are there, there is an issue there because it specifically does mention the qualification of judicial members. But no, but only the qualification of judicial members are mentioned. So, rationalization of that part is very important. Similarly, when it comes to appointment, what is the influence of the executive on appointments? Related to that, you can suggest reforms. You can also talk about some specific countries. Like if you look at the Western countries, you will find that in most of the Western countries, any such quasi judicial body that exists has a very large tenure. Like if you look at a country like France, most of the quasi judicial bodies there does have a no they have the jurisdiction of what? Of 5 years. The tenure is 9 years, not 4 or 5 years like in India. It is 9 years. Okay, no, in this case, Malikarjun, they have actually asked you the year. They have asked you the year 2024. They have asked you the year. Okay, if they do not ask you the year, which means that the last 2 3 reforms that are there, you have to write about them. But in this question, here you will find that there is specifically the year, when reforms were taken. They have actually made no they have mentioned it. Okay, so most of the questions would, in most of the questions, you are very likely to get objectively what year reforms they are talking about. But as it is, because our syllabus talks about quasi judicial bodies, and the most important quasi judicial body is administrative tribunal, so we have to be prepared related to questions specifically related to reforms regarding this. Okay, let's move on. Compare and contrast the president's power to pardon in India and in the US. Are there any limits to it in both the countries? What are preemptive pardons? What are preemptive pardons? Okay. First of all, do you know why this question was asked? Why did UPSC decide to ask this very question? That there are some notes not uploaded in public. Okay. Aditya, I will look into it. And if there is something missing, I will add to it. Okay, don't worry. This question of preemptive pardons. This question of preemptive pardons. What exactly is the reason? So, if you know, last year, when the US president, the outgoing US president, Joe Biden, when he was leaving office, so Joe Biden did what? Joe Biden specifically gave preemptive pardon to his family. So his own son, Hunter Biden, he was involved in a scam related to the Ukraine crisis. So for whole of his presidency, he was saying that he is not going to give pardon to him. But what happened was that after he knew that, okay, Donald Trump has won election and he's going to come to power. So Donald Trump was very likely to do what? Donald Trump was very likely to take this into consideration. And he was very likely to investigate this matter, because that is what he had been talking about during his election campaigns, etc. And that is the reason why what Joe Biden did was he gave preemptive pardon to most of the members of his own family. Okay, that is the reason why this particular question was asked. Okay, now first of all, before getting into what is preemptive pardon, because that is the last part of our question, let's first understand the pardoning powers. And that is obviously with respect to the Indian president. With respect to the Indian president, it is mentioned under Article 72 of the Indian Constitution. And under Article 72 of the Indian Constitution, the president has been given the power to do what? To provide either pardon or reprieve or respite, remission, or even suspension or commutation of the punishment. Okay, so it's not just the pardoning power, it goes beyond the pardoning power. It includes reduction of sentence, or reduction of maybe the nature of punishment can be changed, or an individual can be completely pardoned, or an individual, if there are some special circumstances like an individual who is pregnant or disabled, for them there can be some special provisions made, or for that matter suspension of a sentence, which means not something which would apply instantly, rather there would be a future date from which it would be applied. All these powers are there with the Indian president related to punishment under union law or death sentences, as we know, and also the court martial. Okay, so even an individual who is subjected to military punishment under by the military court, like court martial, that individual can also be pardoned by the Indian president. Okay, now when it comes to the nature of pardon that the Indian president gives, first of all, it is not absolute by nature, which means it is subjected to judicial review. And this is what the Supreme Court says in the Keher Singh case. Okay, Keher Singh versus the Union of India case, the Supreme Court made it very clear that this is not the absolute power of the president, and it can be reviewed by the by the judiciary. Okay, second, which means it is subjected to judicial review. Clear? Secondly, when we compare it to the pardoning power of the president of US, things are a bit different here. The president has this power in the Constitution, Article 2, Section 2, and the president has the power to do what? Power to grant reprieve, or for that matter, pardon for all offenses against the United States, except in the case of impeachment. So if it is a if it is a problem related to impeachment from office, except for that, all the cases can be pardoned. But how is it different? Where the Indian president, the scope was not absolute, but here it is absolute. Here it is absolute. Okay. Here it is for federal offenses, and it is also absolute. It is what? It is absolute. That means the president, once he gives pardon, when he exercises this power, it cannot be subjected to judicial review, as it has been mentioned in the 1866 ex parte Garland case that was there in 1866. It was said that this cannot be reviewed by the court. Okay, so when the US president enjoys this particular power, that is not subjected to judicial review. It is not subjected to judicial review. Okay, there also It applies to all federal offenses, like in India, union list. Here it is federal offenses. And it includes what? Pardon, commutation, remission of fines or reprieve, which is very similar to that of the Indian president. Okay. But there is a difference, which the reason why this question was asked was related to preemptive pardons. Now, what is the meaning of preemptive pardon? Preemptive pardon means even before an individual has been found guilty, or for that matter an investigation, even before an investigation is conducted, the individual can be given pardon. So if you look at, now as I was talking about Hunter Biden and Joe Biden's family, you will find that Joe Biden's family and Hunter Biden, they have been given pardon for a very specific date. So you will find that the the pardon that was given, it says from the year 2013 till the year 2024. That means all this, during this particular 11 years, whatever they have done will be pardoned. Even there would be, even before a person has been formally convicted, or for that matter even before they are charged, they have been given pardon. Okay. And as I said, Joe Biden used it, and it was also used by Richard Nixon. So Nixon was he was found guilty of corruption cases in the Watergate incident in US, which happened in 1974, and that is where he was preemptively pardoned. Okay. Moving on. Discuss the nature of Jammu and Kashmir Legislative Assembly after the Jammu and Kashmir Reorganization Act 2019. Briefly describe the powers and functions of the Assembly of the Union Territory of Jammu and Kashmir. Now, we know that in 2019, the Article 370 of the Constitution was amended. It still exists, but the primary power that was given to the Assembly of the of Jammu and Kashmir, that has been taken away. That has been taken away. Okay. So if you look at as of now, Jammu and Kashmir is what? As of now, Jammu and Kashmir, with the reorganization, with the division of Jammu and Kashmir into two union territories, Jammu and Kashmir, a union territory with legislature, and Ladakh, a union territory without legislature. Okay. So Jammu and Kashmir is no more. Jammu and Kashmir is no more. Jammu and Kashmir is no more a state. It is a union territory with legislature. Okay. And because it is no more a state, and we know that when we talk about federalism, and when we talk about federalism, and when we talk about the very concept of, where we talk about the very concept of federal distribution of powers, this federal distribution of powers that is there, it is related to what? It is specifically related to only the states. The union territories do not have this distribution of powers. So that is the reason why you will find that whenever there is, whenever we are talking about the distribution of powers between center and state, we are always talking about states. And when union territories have been given legislature and they have been given some specific powers, they do not enjoy the same powers that are that whether it is legislative power or whether it is executive power as the state enjoys. Okay. So what is the situation as of now? The situation as of now is that they have powers similar to under Article 239A. In fact, if you look at the union territories of Delhi, so the NCT, the National Capital Territory of Delhi, and Puducherry. So the National Capital Territory of Delhi and Puducherry, both of these that are there, both of them are what? Both of them are having, a legislature. Both of them are having a legislature. Okay. Now, so the powers that are being enjoyed by the legislature of Jammu and Kashmir, that power is now also all no, it is similar to what the National Capital Territory enjoys or what Puducherry enjoys. So not like that of state. Okay. And there is also the office of lieutenant governor, the office of lieutenant governor. And you will find that the office of lieutenant governor that is there, the office of lieutenant governor also plays a very, very important role. What? They play a very, very important role. Okay. Now, what are the powers? Lawmaking powers. They have lawmaking powers, but they do not have all lawmaking powers. Why? Because subjects like public order, police, and land, if you know, you would know this, that when it comes to NCT, okay, when it comes to NCT, that is their National Capital Territory, you will find the National Capital Territory, the Legislative Assembly of National Capital Territory does not enjoy all the powers and all the areas that are mentioned in the state list. Okay. It is not meant, no, it does not enjoy that. Why? Because it does not enjoy powers related to public law, public order, or for that matter, police or land. So in these cases, the power belongs to the center. The power is not there with the Legislative Assembly of the state. Okay. Moving on. Then comes financial powers. So there are some financial powers also, like budget, etc. There are certain powers, control over executive, that means through the check and balance principle, they enjoy certain powers there as well. They also enjoy power related to representing, that means they represent the people and the concerns of the people. But there are a lot of subjects which are kept under the power, no, under the parliament and the lieutenant governor. So because it is not a full-fledged state, that is the reason why it does not enjoy the distribution of power which is there with other states. Okay. Okay, let's move on. Aman, I have seen your comment. Because I was in between of this question, that is the reason why I'm not answering it. I know what is remaining, don't worry. Everything that is remaining would be done. I know that there is one class that is remaining in the governance part. Don't worry, I'll be, we will be doing that. Okay. Moving on. Then comes a question on Attorney General of India. Okay. The Attorney General of India plays a crucial role in guiding the legal framework of the union government and ensures sound governance through legal counsel. Discuss his responsibility, rights, and limitations in this regard. Now, this question that is there, this question is a very simple question. It simply demands your knowledge of, Article 76 of the Indian Constitution. So if you know Article 76 and the provisions related to that, if you have read any book on polity where you have read about Attorney General, you will be able to write about it. You will be able to write that how he is the highest law officer of the union government, how he is the one who gives legal advice to so he acts as a chief legal advisor to the government. Not only just that, he also has responsibilities such as representing the government in the court, defending the union government. So whenever there is a case where union government is made a party, in that case, the Attorney General will always represent, it will be the Attorney General which will represent the union. Okay. And along with that, there are other issues like guardian of constitutionality, which means it also helps in doing what? All the policies and laws that are being made, in order to ensure that it is consistent with the constitution and the other laws, Whenever such policies and laws are being made, the Attorney General will always provide his or her advice to the union government. Okay, so this is basically what his role is. What is his rights? Right to audience in all Indian courts. So he can, he can go to all Indian courts, be present there, and he could observe the proceedings. He has the right to participate in parliamentary procedures. So you know that Attorney General can sit in the house, participate in the parliamentary procedures, though he does not have the right to vote. No, he does not have the right to vote there, but he can attend the meetings of the parliament, and he also enjoys parliamentary privileges. He also enjoys parliamentary privileges. But there are certain limitations also, like the office is not a full-time council, which means it's not that an individual who is a private practitioner in law cannot be appointed as the Attorney General. They can be appointed. Okay. Similarly, cannot defend cases against the union government. So if he is into private practice, he cannot take those cases which are against the union government. He cannot take those cases. He cannot advise or represent parties when there is a conflict of interest. So if there is a conflict of interest with the government, so if there is an individual who is a private practitioner and there is a conflict of interest that is there, in that case, very likely he would not be able to participate there. Along with it, he is not a government servant, obviously, like he is not like a minister or any other public servant, and he holds office during the pleasure of the president, which means at any given point of time, the president can remove the individual without due reasons for the removal. Okay, so these are the limitations. It's a very factual question that is there. This time there have been multiple questions which are very factual in nature which has been asked. Okay, see this question. What does it say? E-governance projects have built-in bias towards integration, then user-centric design, examine technology and backend. That means what we have to look at is the question that is asked. The question is related to the substantiating the idea, the manner in which e-governance services are used. The focus of e-governance services is not about what? It is not about ensuring the user-friendly services. So most of the people are unable to use e-governance services because it's complicated. So the focus is what? The focus is not usage of it. Rather, the focus is integration of design or technology or backend. That is the focus. So the focus is more technical than making it user friendly. Okay, that is what the demand of the question is. So why are we talking about this? See, tech first orientation. Focus is on what? Focus is not on providing user friendly services. So you will find that if you look at digitalization of records, data integration, IT platforms that are there, it is not easy. It is not easy to be capable of using it. And the best example of it is the GST. The initial problems that were there with respect to the GST when the GST reforms were taken up was because of the lack of user friendliness of the technology that was there. When the platform was initially established, there were a lot of problems with respect to how it is to be used. And even today, rather than people being capable of using it by itself, they have to they have to go for experts, pay the experts in order to file their GST and file their GST returns, etc. Even today that is the problem. And this is what we are saying. Focus is on tech, not on user friendliness. Second, top down design. One of the most important problems with e-governance is that e-governance is mostly a centralized effort. So e-governance efforts that are there in India, these are not bottom up, these are top down. So you will find that the union government and whatever portals are established, whatever networks, whatever portal, websites, apps that are there, all of them is done through a top down system. So that again becomes a problem. Why? Because it does not take into consideration what does the user want. Okay. Thirdly, emphasis is on what? Efficiency. Again, as I said, focus is on what? Automation, not on government to citizen relationship. How to ensure better citizen government interface. That is not what is the focus. The focus is what? In order to make it more efficient. That has always been the focus. Okay. Digital divide, one of the major concerns that is there. So people living in rural areas, people living in urban areas, there is a considerable digital divide that is there. Though there have been some steps that have been taken by the government, like if you know national e-governance program, you know that one of the major initiatives under the national e-governance program has been the establishment of common service centers. Establishment of common service centers at the rural level, in order to ensure that people living in rural areas are also able to access e-governance related services. But again, a very limited, though there are number of, the number of common service centers have been established, but usage of it still is not as effective as what was visualized. Okay. Fragmentation. When we say fragmentation, what does that mean? Multiple portals. So there is no one common portal. Like suppose the government should have one portal where every service could be accessed through that very portal. That is not what we see. What we see is that most of the times there are multiple portals for everything. If you have to file GST return, you have to go to another portal. If you have to access maybe Aadhaar and make some Aadhaar related request, you have to go to another portal. If you want to file your IT return, therefore that there is another portal, and there are n number of portals which are there. So rather than trying to combine it and integrate it into one portal, allowing better accessibility, that is not what has happened. Okay. Now because of this, what happens? When you have multiple portals, there are a lot of fake portals also that come up, and the address, the URL address is such which is disguised. It seems to be a government portal. So you would find that there is an institution which has come up with a portal like gov.in or something very close to it, gov.co.in, something like this. So they will do that, and accordingly what happens is people thinking that it is a government website land up on private websites, and there is also data theft that goes on in that very sense. Okay. So user friendliness is what is missing in e-governance. Most of the steps that have been taken for e-governance, what we see is that there is a problem related to that aspect. Okay. You can see low adoption rate, citizen prefer intermediaries. So if I would, as I said, I have to file a GST return, rather than filing it myself, rather than filing the GST return by myself, what I can do is I can simply ask someone to do it on my behalf. Rather than doing it by myself, I can ask someone to do it on my behalf. Okay, that is something which is that is something what you will find mostly what we are doing. Even if someone wants to make some Aadhaar related changes, so rather than doing it by itself, what will be done is that there would be I would use someone else's service. So why is that the case? That is because of lack of, as I said, user friendliness, lack of integration. That is the reason. Secondly, exclusion of vulnerable groups. There has been no attempt made by the government or on the part of the government to come up with technology in order to ensure people who are elderly, rural poor, or digitally illiterate, because they are the most vulnerable section, the most disadvantaged section. So how to integrate them into the fold of e-governance services? That is not something which has been done. That is not something which has been done by the No, it has, it's not been done by the government. So that is another problem. Trust deficit, because of what? Lack of grievance redressal mechanism. So if you have attended governance classes that I have taken, I've always given importance to, while we were talking about citizens charter, e-governance and other specific mechanisms also, I have always emphasized on the importance of a grievance redressal mechanism. What we see is that either grievance redressal mechanism is non-existence on these portals that are there, and even if they are in existence, they are not something which is actually working. So they are delayed responses, effective redressal of grievances is not done. These things is again what the problems that we find. Okay, so that is also a problem. Then comes reinforcement of bureaucracy. Instead of reducing red tapeism or poorly designed platforms replicating bureaucratic hurdles digitally, what has happened? E-governance was always to be more efficient because it reduces the interaction between the people and the bureaucracy. But if the bureaucracy has been able to replicate that delay and that problem of red tapeism when it comes to the direct interface that we used to have with bureaucracy, if that is now also present at the digital level, that is where the problem lies. Okay, so that is also the case. What can be done? See this: UX design, user experience design. Focus on this. Focus on not on just creating multiple portals. Focus on refining portals in order to do what? In order to completely change the experience of the user. Secondly, participatory design. That means as we said, the top-down model should be done away with, and new portals, new mechanisms should be adopted with the participation of either civil society organizations, citizens as well. Digital literacy program. Though we have taken up the digital literacy program, but this is not enough. This is not enough. Okay. Then comes one-stop platforms. One-stop platforms like what? Integrated services with single sign-on, like Umang app, or it's a India stack that is there. These are what? These are examples of one. If you have one login, you can log in into those apps and you can access multiple services from one app or from one portal itself. Okay, that is there. Multilingual, very important. Most of the problem, one of the major problem is what? One of the major problem is lack of usage of vernacular languages, because either it is there in English or either it is there on Hindi. But most of the Indians, they are neither comfortable with English or neither comfortable with Hindi. है ना? So in that case, what we need to do? Multilingual platforms that we need to adopt. Okay. This is what we need to do with respect to this. This is how we can write about it. Next comes civil society organizations are often perceived as being anti-state actors than non-state actors. Clear? Do you agree? Justify. Very important question. And there are a lot of things that you can write here. See, first of all, try and understand the contemporary governance phase. If we try and understand the contemporary governance, if we say this is the governance space, so what are the primary actors that are present in this governance space? The primary actors that are present in this governance space are, we can say it's the government or government agencies. Then comes the private organizations. And then comes a large space is also occupied by civil society organizations. Okay. These are the three most important players. There are other players also, but the most important players are these three. Okay. They are the most important players. Now, the question is that This is how we can introduce this question. Okay, writing about or drawing this diagram, writing about the fundamental players of the governance space, we can write about that. And then we can come to this particular aspect. Why is it that the civil society organizations are looked at as an anti-state? Now this is very important. Anti-state actor, that means working against the state. And why does this happen? Because of the role that has been adopted by the civil society organizations. Civil society organizations act as watchdogs. So any law or any step or any such decision which is being taken by the government, they are criticized if they infringe upon our rights or something like that. They do what? There is a watchdog role that is played. Recently itself, if you look at an example, the decision that was taken related to removal of street dogs in Delhi. What happened? The decision was taken in order to remove street dogs in Delhi, resulted into wide-scale protests. Finally, there were animal activists who went to the court there, and finally what they did was they went to the court and they brought a stay on this particular decision of the government. So what happens is that most of the times their actions, because of its watchdog nature, can be perceived as anti-state. Secondly, opposition to state projects. A lot of time developmental projects which are taken up by the state, because obviously development may be contrary to sometimes environment, sometimes the rights of vulnerable section like the tribals or rights of farmers, sometimes these rights are encroached upon in the name of development. Okay, they development has to have that cost. Development has a cost. So that is what the cost is. And what happens is that the civil society organizations, they start mobilizing the people in order to do what? In order to be capable of addressing to the demands of these vulnerable section of the society, and thereby take up steps which are anti-state. Then comes what? International funding and links. Intelligence Bureau of India in 2013 said that because of these foreign funded NGOs, India loses approximately 2% of its GDP. So lot of times foreign fundings are given to these NGOs with a very purpose of taking up activism against the state. So they tend to do what? They tend to challenge almost all actions and all steps that are being taken by the state. If you take a farms law, there would be certain protests that would be taken up. If you tomorrow take up a project in the northeast, there would be environmental groups protesting against it. If you establish nuclear power plant, in that case there would be certain steps that would be, these NGOs would mobilize people. Mobilization of dissent, because as I said, lot of steps of the government, they do what? They cannot, the government can never take a step which with which every individual and every interest can be appropriately addressed. That will not happen. There will always be dissent against the government. There is always going to be dissent against the government. So in that case, what happens is that these NGOs that are there, or civil society organizations, they mobilize that dissent. So dissent which is primarily, it's scattered. Now there is a mobilization of that dissent against the state. Okay. So this is basically the reasons why it is perceived to be anti-state. Why are they non-state and not anti-state? Obviously, you cannot just end your answer here. So you have to present a contrary opinion, like they play a complementary role. There are so many services today where the government uses NGOs and civil society organizations, like the self-help group. And you will find that today, rural development, the most important vehicle of rural development has been self-help groups. the most important vehicle of achieving women empowerment has been self-help groups. Okay, so that is there. Policy advocacy. A lot of times NGOs that are there, they participate and they advocate policies to the government. Sometimes they also meet ministers. They give proper, no, they play an advisory role there also. They build trust, social capital building. Always I use this term, that we talk about social capital, trust. So what they do is, because there is a democratic nature of these civil society, because people participate, citizen participate in the civil society, no, their activities. So because of the democratic participation, the trust that is there, it increases. And when there are institutions like the RTI, there are institutions like the anti-corruption institutions like Lokpal, and they use these mechanisms. And when they are able to use these mechanisms, the trust is further with more. No, what does this bring? This brings transparency. Transparency brings trust. Bridging gap. Now, when we say bridging gap, what are we talking about? We are talking about those areas where the state is weak. When it comes to disasters, when it comes to marginalized section, when it comes to environmental norms and all of this, these are areas where the state may not be, they may not emphasize a lot on. So what happens is that there is a role, that is a very important role, that is played by the civil society organizations here. Okay. Then obviously there is a balanced view. There is a need to do what? There is a need to work together, not against each other. And that is how you conclude this answer. Next comes very, very important. And the reason of it, the reason why this question has been asked is also so important. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. In the view of the above observation of the Supreme Court, explain the concept of constitutional morality, its application to ensure a balance between judicial independence and judicial accountability. This question has been asked in the very background of what happened in judiciary. In the Delhi High Court, a judge who has been found to be guilty of corruption and is almost on the verge of being removed. So this is the reason why there is a need to balance judicial independence with judicial accountability. We need to balance this. And in order to balance this, constitutional morality can play a very important role. This is what the question is. Okay. I have simplified the question for you. This is what the question is. Now, how will you address this question? Obviously, introduction of your question would be you explaining constitutional morality. So you will mention that constitutional morality goes beyond law. It goes beyond just the enforceable part of the constitution and laws. It has to be about what? It has to be about values, about principles, and about the ethos of the constitution. That is what constitutional morality is. As B.R. Ambedkar says, respect for the forms of constitution and adherence to its spirit, even when it is inconvenient. Even when it is inconvenient, you being capable of doing what? You being capable of following the spirit of what the constitution says. That is what constitutional morality is. Okay. Now, question is how is a balance? No, how can constitutional morality bring about balance? See, constitutional morality also, first of all, how does it bring about judicial independence? Independence, judiciary independence has been guaranteed under Article 124 to 147, as well as the 214 to 231 related to high courts. It ensures that judges are insulated from executive interference. You'll find that the executive does not interfere with the working of the judiciary, though it is capable of doing it by maybe coming up with, introducing laws or bills in the parliament, passing laws, bills in the parliament in order to do what? Enforce something on the judiciary. But that is not what the executive does. Similarly, political pressure as well as populist demands. So, constitutional morality helps in this regard, balancing populist demands with what is right, the values of the constitution like justice, equality, balancing between them and what the populist demands are, or balancing between the political pressure that may be exerted on the judiciary, because judiciary in India has not been immune to political pressure. We know that there have been cases where the judges of the Supreme Court have been, they have been superseded in order to appoint judges with lower seniority as chief justices of India. That has resulted into even resignation of judges. So it's not that judiciary has been immune from, they have been immune from the interference of the politics. That has not been the case. And also populist demands, as we have seen. Now, how has the judiciary been able to address this? So judiciary has been able to address this by taking up some specific steps, like giving some specific decisions in order to ensure independence of the judiciary, even though the decisions may not seem to be as per what the provisions of the constitution say. And the biggest example of it is the system of the collegium, which has been introduced in order to do what? In order to ensure its independence. That is what in the second judge case was said by the Supreme Court. The Supreme Court said that it is an exercise, appointment of judges is an exercise whereby the best candidate is selected for the position, and therefore the judicial opinion expressed through the Chief Justice of India shall be it shall be enforced, or it shall be accepted by the president. So the concept of consultation being it involves concurrence. That idea was given in this very regard itself, in this very background itself. Clear? Judicial accountability. How judicial accountability has to be ensured? Independence must not turn into unaccountability. What has happened recently, where a judge of the Delhi High Court, because the judiciary is not accountable, and there are lot of laws which otherwise brings accountability on other organs but are not related to judiciary. Case in point being the RTI. So RTI is not applicable against the judiciary. So the accountability mechanism that is there, in order to ensure independence of the judiciary, it should not turn into becoming an unaccountable institution. That should not happen. Okay. Secondly, constitutional morality ensures judges are guided by constitutional values and not by personal biases. Clear? Thirdly, mechanisms, judicial conduct standards, impeachment, in-house procedures, public reasoning in judgments. These are what? Again, what is the basis of it? When it comes to public reasoning in judgments, in order to ensure that the constitutional morality, that is the values of the constitution, are upheld. Clear? That part. Then comes the NJAC being struck down on what reasons? Independence of the judiciary. There is a need to do what? There is a need to bring about a balance between the two. How? Preventing executive dominance but also preventing judicial arbitrariness. And again, by following the values of the constitution, by following the spirit of the constitution, by following the ethos of the constitution, this can be achieved. Okay. Next, Indian constitution has conferred the amending power on the ordinary legislative institution with a few procedural hurdles. In view of this statement, examine the procedural and substantive limitations on the amending power of the parliament to change the constitution. Clear? The question is a very simple question on amending power of the parliament. Okay. So the first introduction part of this very discussion, what would be the introduction part of this discussion? So in the introduction part of this discussion, you can write about the need for flexibility in the constitution. See, constitution cannot be a rigid document. That means it is rigid does not mean it cannot be amended. So the provisions of amendment should definitely be made to the constitution so that the constitution can remain relevant as of today. For ensuring relevance of the constitution, this is necessary. Okay. Now, the body part of your answer should be parliamentary procedures regarding it. So you can talk about the parliamentary procedure, where you can mention Article 368 of the Constitution. You can mention Article 368 of the Constitution. Along with mentioning of Article 368, you can write about the procedures involving special majority. Because the question also says what? The question says that there are certain procedural and substantive limitations. So what are those procedural and substantive limitations? We should know about them. So the procedural and substantive limitations are what? The procedural and substantive limitations are ensuring, first of all, that a constitutional amendment is passed by a special majority, ensuring that Rajya Sabha as well as Lok Sabha enjoys equal powers, ensuring that there is no joint sitting that is held, ensuring that if the provision that has to be amended it is trying to alter the federal features, so ratification of the states becomes necessary. So what are these? These are procedural limits that are imposed in order to ensure that there is no arbitrary constitutional amendment that is done. Okay. Then comes substantive limitation. So when we talk about substantive limitation, you can talk about substantive limitation in the form of the basic structure doctrine. Basic structure doctrine. You can talk about the basic structure doctrine, and you can mention that how, when we talk about the basic structure of a constitution, as per the judiciary, you can mention the Keshav Nanda Bharti case. You can mention other cases also where the Supreme Court has used this basic structure doctrine to ensure that there are no arbitrary amendments that are done. So you can mention that how in the Keshav Nanda Bharti case, by the Supreme Court coming up with a judicial innovation in the form of the basic structure doctrine, imposed substantive limitation on the amending or amendment powers of the legislature. How? By ensuring that the basic principles, which though the judiciary does not define what the basic structure is, but we know that it consists of the basic pillars, the basic philosophy of the constitution. And you can write about some cases like the Keshav Nanda Bharti case. The Keshav Nanda Bharti case, and how in the Keshav Nanda Bharti case, the Supreme Court declared judicial review as a part of the basic structure. How? secularism has been declared as a part of basic structure, and so on. SR Bomai case, and you can mention other cases as well. Okay, so this is basically the answer to this very question. Moving on, discuss the evolution of collegium system in India. Critically examine the advantages and disadvantages of the system of appointment of judges of the Supreme Court of India and in that of the US. Okay, so what we have to do is, this is again a question on constitutional comparison that has been asked. Okay, a question is there on constitutional comparison, because we have to first write the procedure that is there in India and then compare it with that of US. Okay, now obviously we will be first starting our question by writing article 124 of the constitution, and how article 124 of the constitution talks about what? The appointment of judges of the Supreme Court in the form of Chief Justice of India being appointed by the President, and the President can consult any number of judges from the Supreme Court and the High Court. Then how the other judges of the Supreme Court are appointed by the President, again by consultation of the Chief Justice of India, and along with Chief Justice any number of judges of the High Court and the Supreme Court. Then you can write about what? Then you can write about the first judge case, first judge's case. In the first judge's case, what can you mention? The second judge's case. So what is the difference here in the first judgment of the first judge case and the second judge case? The SP Gupta case, the first judge case, was where they said concurrence is not consultation. So consultation is not concurrence, which means that though the President has to make available all factual information which it is considering to appoint a judge to the Supreme Court, but it does not mean that it has to abide by the advice given to it by the Chief Justice of India. That is what it says. Consultation is not concurrence. Whereas this changes in the second judge's case, and here concurrence and consultation. So now the Supreme Court says that in the Skara case, Supreme Court advocate on record association versus the Union of India case. In this very case, what did the Supreme Court say? The Supreme Court now says that, as I just told you, that as the observation of the court was, as the exercise to appoint the judge in order to ensure that the best possible and the most meritorious judge is appointed, the recommendation of the judiciary given to the President through the Chief Justice of India would be considered as mandatory for the President to follow. That is what it says. But it also established the collegium here. That means the decision of the Chief Justice would not be only the decision of the Chief Justice. Rather, Chief Justice would frame its decision by consulting some judges of the Supreme Court. Then comes the third judge's case. And in the third judge's case, what did the Supreme Court do? Established and elaborated on the collegium. How appointment of judge of the Supreme Court would involve Chief Justice of India plus 4 senior most judges. Appointment of judges of the High Court involves, what is the collegium? You will write about that. Then comes the 2015 NJAC case, National Judicial Appointments Committee case, where you can mention here NJAC, how this was later on called as the fourth judge's case as well. You can mention how it is called as the fourth judge's case, and you can mention the provisions of how the Supreme Court here declared an NJAC to be unconstitutional on the grounds that it encroaches upon the independence of the judiciary. You can write about that. And then you can mention what? Then you can mention the positives and negatives of the NJAC. You can mention that the collegium that is there, how collegium is a violation of separation of powers. How judges are appointing judges. Judges are appointing judges. How there is no transparency with respect to it. No transparency with respect to it. Also, you can mention the negatives here. That means why collegium system should be present. Judicial independence, you can write about it. How judicial independence is important for any democratic system to exist. You can write about that. You can also write about the fact that how, in order to ensure that the executive does not exercise no overarching authority, arbitrary authority over the judiciary, arbitrary authority over the judiciary. So you can mention that. Clear? So this is where we address collegium. Now comes the US, and what is the provision related to US? So in US, the judges are appointed through a step by step process. What is the step by step process in US? In US, the process starts with the one of the judges of the Supreme Court either resigning or passing away in office. Because in US, there is no age limitation for retirement. Okay. Then, because the seat is vacant, so the president appoints the judge. The president appoints the judge. Once the president appoints the judge, now comes the role of Senate. And the Senate committee takes up hearing. And finally, the Senate committee votes and confirms appointment. This is the process that is there. You can write about this process also. And because the question asks what disadvantage and advantages of Supreme Court of India and US. So you can write about what the advantages and disadvantages here are. So here you can see advantages part. You can see advantages part in the form of what? In the form of that there is legislative check. There is legislative check that is there on how the president is functioning. But there is a disadvantage here also, because the president can send anyone's name. There is a disadvantage because you will find that Senate generally confirms the name of the judge which has been sent by the president. Accordingly, you can frame some advantages and disadvantages. Okay. This was the question. Now, what are the environmental pressure groups? Discuss their role in raising awareness, influencing policies, and advocating for environmental protection in India. Very simple, straightforward questions. There is nothing complicated about it. So, how will you start this question? You will start this question by mentioning about what is the environmental pressure group and giving some examples related to it. Giving some examples related to it. So, what are the environmental pressure groups that are there in India? Can you name any of them? Yes, anyone? Can you name any of such groups? Hmm. In India, You can come up with these examples. Okay. After which you can talk about their role, raising awareness, educating the people on ecological concerns like deforestation, pollution, climate change, displacement, using media campaigns, grassroots mobilization, and protests like Chipko movement, as we have just seen as an example. Save Silent Valley campaign, another example. Recently, there was a incident in Jammu and Kashmir related to the Raika forest. Raika forest, they do that. Next comes influencing policies, pressure, pressure governments for employee friendly laws, stricter enforcement that can be done. Like if you look at example of 1986 law, environmental protection, it was done post the Bhopal gas tragedy. In environmental impact assessment norms, or for that matter when we talk about the forest right acts 2006, all of these are what, all of these were the result of the such organizations playing an important role there. Along with it, you can see legal interventions can be done like PIL. A lot of environmental groups, they go to the Supreme Court against the decisions of the government, against laws that have been taken up by the government. So even if you take the case Ganga pollution, vehicular emission, Taj trapezium zone, NGOs like Legal Initiative for Forest and Environmental environment, that is life, they use it. Then comes advocacy and global linkage. So even international mobilization that is done, how UN organizations and how these organizations represent certain problems that are there in related to an environment in the UN, and therefore influence the stand of India. Okay, very simple question that was there. Okay, so these are the specific questions that was asked in your GS paper 2 related to the polity and governance part. I hope this would enlighten you related to how you can approach your mains examination, specifically for students who are likely to appear next year prelims examination. When you are appearing for prelims examination, after that how you should be coming up with structure of your answers, how you should be addressing concerns, what are the important issues, because most of the issues that we have just discussed which appeared as a question, that all of these issues were in news for some or the other reason. So how and what aspect of current affairs becomes important for the polity and governance part, all of this is what our objective was, so that you would be able to address these concerns and accordingly do well in your mains examination. Okay, so that is it for today. Thank you everyone. Thank you so much for being here. Thank you.